criminal defense attorney Ashley Bargenquast is with us. Ashley, I have to talk about this theme that seems to be intertwined throughout this trial. The defense really hammered it home during their opening statement, and that has to do with the impact of the COVID-19 pandemic on the mental state of all of the people involved. And we're hearing it now in these arguments where they're trying to talk about the ex-husband of the victim and how he felt about his ex-wife at the time. But tell me about what you think about the jury needing to understand and remember what it was like during that time for people during the pandemic.
Yeah, thank you so much for having me. So I hear when I'm hearing these arguments back and forth that, of course, all of us were experiencing, including the jury, a lot during shelter in place in the COVID pandemic, and reminding the jury of that state, of the circumstances surrounding everybody's experience at the time is crucial to know the state of mind of everybody involved. I hear this argument a lot in many different cases of particularly prosecutors saying, I don't find it relevant to go into any number of prior acts, any number of things that the defendant has experienced, et cetera. And they will say, you know, it's not towards the element of the crime, so therefore it's not relevant. But those circumstances are extraordinarily relevant. They are what everybody was experiencing at the time. And so I understand the defense attorney's frustration here, because without those circumstances, the court and the jury, most importantly, is receiving this in a vacuum. But life isn't in a vacuum. Life has so many things that are being considered and experienced.
Yeah, and it's a very nuanced defense in that it's not self-defense. It's, I was drunk, she was drunk, and she's a really bad person. And I killed her, and then I put her in a pond. That's their biggest problem. Does he have to get up on the stand? He's a doctor, he's a surgeon. He should, one would think, be able to communicate properly. And this is such an odd defense that I don't know how you're gonna, because to me, all right, well, you put her in the pond, dude. You didn't call 911 after you accidentally killed her. I mean, could he be a guy, which I get it, normally you would never put a person like this up, but could he maybe save himself?
It's difficult, right? Any case like this, having the defendant take the stand is a risk. And I mean, frankly, because he is a surgeon and has this medical background, they say you never want your surgeon to faint at the sight of blood, right? But how will the jury react if he's able to remain calm and collected when talking about this? Because clearly the defense here is that he panicked, right? They were in this argument. She died, and those are the circumstances that are kind of being tried back and forth. And instead of reporting it as one usually would, he put her body in the pond because obviously there was some sense of, I don't want to go through regular channels. So without his testimony, I'm not sure how the defense is going to get that clear explanation in, but it is such a catch-22 because somebody on the jury is always going to think that, well, if he really was innocent, his facial expression would have done X or should have done Y.
Yeah, they overanalyze everything once you're on the stand.
Oh, for sure.
Just forget about the rest of the trial. It's all about the defendant.
And I don't know if the defense attorney was teasing that he may take the stand when he made sure the jury understood the background of where the defendant is from, what his accent may sound like if he's talking and they're hearing it, but we don't know. Nothing clear of whether or not he's going to be taking the stand. Ashley, stand by. We're going to get to a break. The ex-husband is no longer on the stand. The attorneys didn't have any questions for him. So what's coming up is a detective who interviewed the defendant